So welcome to our webinar on charities and policy advocacy during the federal election. What you need to know. I'm Owen Charters. I'm President and CEO with Boys and Girls Clubs of Canada, and the Pemsl Case Foundation has asked me to moderate this webcast discussion today on the rules affecting public policy advocacy by registered charities, especially during the federal election campaign. And I'm joined by Pemsl board members Susan Manwaring and David Stevens. Welcome today. It's great to have you with me to talk about these important issues. A little bit about the Pemsl Case Foundation, in case you don't know some of the background. It was founded in 2010, and it does research and participates in court cases on charity law. Its aim is to educate leaders of Canadian charities and the public about legal and regulatory issues affecting the sector. And this webcast is actually part of their the inaugural session in some of those educational efforts. We're hoping today to share some insights into the area of public policy advocacy, as there have been a lot of recent changes in the Income Tax Act legislation dealing with this issue, and there have been lots of public statements, some which may be accurate, some less so, about what charities are now permitted to do. It's important that leaders of frontline organizations understand these rules and that charities abide by them so that you don't get into trouble. So this webcast focuses on questions that we think will be of interest to executive directors, to CEOs and board members and others in frontline charity groups. As I mentioned earlier, I'm joined by Susan Manwaring and David Stevens, who have both been dealing with charity law issues for many years. I think, and we all think, that they'll be helpful guides to what is, to many of us, uncharted territory now. By way of introduction, Susan Manwaring is a leading expert on advising social enterprises, charities, and nonprofits in her law practice. She provides both general counsel and specialized advice to her clients across Canada and internationally. She's the national lead of the social impact group at Miller Thomson, and she's been named as a member of the newly established federal government Charities Advisory Committee. David Stevens is a partner in the business law department in Gowling WLG in their Toronto office. David is a tax lawyer focusing on corporate and international tax planning, personal and private company tax planning, trust taxation, mining, and charities, and not-for-profits. Among other things, his personal tax and charities practice deals with private foundations and charities compliance issues. David was a law professor at the Faculty of Law, McGill University, from 1983 to 1999. So welcome to you both, and I'm looking forward to the discussion today. I think the piece that I mentioned in the introduction is that we're in an election right now, a federal election, which raises interesting questions, and I think all of us hear all sorts of questions about what are we now allowed to do as charities. But more broadly speaking, there's been a lot changing in the charity law landscape around advocacy and what charities can do. This is often referred to as public policy dialogue and development activities, but in the technical term, or PDAWs, if you're listening to someone from the CRA. We'll refer to a lot of that today as advocacy activities by charities. And David, I want to start with you. What do you see as some of the biggest changes that charities really need to be aware of in terms of those sorts of activities? What can they do now, or what should they be considering in terms of prohibited activities at this point?
So it's important that people understand the history of political activities and charity law. And I think it's probably well known that the common law took a very strong position that doing politics was not the same as doing charity. A political purpose is not a charitable purpose. And that comes out of a couple of older cases from the UK, and also some more recent cases in the Canadian context. That position causes confusion a little bit, because people really don't understand the distinction between, or generally speaking, people have difficulty with the distinction between politics or advocacy and charity. What counts as advocacy or politics that's not charitable, and what counts as a charitable purpose. So that's all changed very recently, first with a Superior Court decision in 2018, and then more recently with changes to the Income Tax Act. And what's happened in the law now is that distinction essentially has been dropped. It's to a large extent in any event. So now it's all right under the Income Tax Act for a charity to carry on advocacy activities to the extent of 100% of its resources, provided those advocacy activities are in line with or in pursuit of their charitable purposes. So you still have to have charitable purposes. You can't have advocacy or political purposes, because those purposes aren't charitable. but your activities could be advocacy oriented or political if they are in pursuit of that charitable purpose to the extent of 100% of your resources. So that's a huge change in permitting what was formerly prohibited to charities. The formal prohibition wasn't categorical. The formal prohibition said that charities could carry on political activities, but only to the extent that they were incidental and ancillary to their charitable purposes. And the Income Tax Act codified that in a quantitative way and said, well, that's basically 10%. So if less than 10% of your resources are devoted to political activities, then you're okay. But that's a means and kind of distinction, incidental, ancillary, less than 10% were permitted, provided 90% of what you were doing or your ends were entirely charitable. So historically, it wasn't an absolute prohibition. It was a major restriction, but that major restriction has been removed. Now it's permissible for charities to carry on advocacy activities, except, this has always been the case and still is the case, except if those activities are partisan in nature. A charity is prohibited from carrying on partisan political activities.
I was going to ask about that actually, and I'm glad you raised that, because when you mentioned political versus charitable activity, I think a lot of people immediately think of the term political as being partisan, which is not the case. Partisan is something quite distinct, and I think given, especially in an election where the whole world becomes much more partisan, can you just go a little bit deeper in terms of what, there's still 100% restriction or prohibition on partisan activity.
That's right.
Meaning what?
Well, the formulation is direct or indirect partisan activities, and what that means is participating in the either during an election or outside of an election, participating in political activity in a way that advances the interest of a partisan political party, and then directly or indirectly would be caught by that. So that's political, partisan political, and that's prohibited.
And Susan, are you finding, I mean, these are sort of the questions that are coming up, that this is very practical now. Charities are finding themselves in this space. We're seeing, I think there was a real question around, are the political activities, for instance, of environmental groups, those are some of the good examples that have been caught in the crosshairs prior of political activity and whether they're overstepping their bounds. In fact, are they getting into partisan activity, as an example? Are you seeing that there's been I guess it was called the political activity freeze or chill, the advocacy chill. Is this reducing the chill, or is it, what does this now mean for where charities are going? Are you seeing a change in their behavior?
Well, I think in the context of the Income Tax Act rules, which is what David's been talking about, around what we did call political activities and which are now PDAs or advocacy that's not partisan, the chill was starting to go away because people really understood that the Income Tax Act and the requirements around how to spend their charitable activity was changed such that they could go out and spend their resources in furtherances of their charitable purposes on advocacy, provided that it wasn't partisan. What's been of interest in the last few months is the fact that as the Income Tax Act requirements changed, we also embarked on a federal election in the country, and the Canada Elections Act has rules that apply for purposes of regulating amounts expended by candidates or political parties and also third parties on election issues. And in the context of that regulation, which has been changed in the last year, the same terms are used. They talk about partisan advertising. They talk about supporting candidates. And in that context, there has been some confusion around whether the Elections Act was being somehow, would be seen to be a tool today that would bring back the restrictions that had been previously applied or were perceived to be applied on charities. But in fact, what the Elections Act is about is really about regulating the amount of money that can be spent by a candidate or a party in the context of the election. And it includes third parties who want to spend money advertising in support of particular issues or particular parties in the context of the election. It's not about saying, as a charity, you can or cannot do something. It's about a rule that applies to anybody, charity or otherwise, as to how much you can say in support of a particular party and it's really a registration regime. It's a regime about if you spend over $500, you have to register with Elections Canada and you have to tell us what you're doing. You have to account for the money you're spending.
Well, and this created a bit of confusion because I think, as you said, charities were looking at their advocacy rules and saying, okay, we're off the leash now. The 10% restriction doesn't apply. We can do whatever we want on a political basis. Oh, but now we're being told, or so it seemed until Elections Canada sort of walked their statement back a bit, that they had this other restriction. I don't think people were expecting, charities were not expecting to hear from Elections Canada in their activities. Has this rule always been there, but this has been sort of subservient to the broader prohibition that used to exist, so it wasn't an issue? Or is this new in some way?
It's somewhat new. I mean,
Okay.
the Elections Act has always been there. There's always been certain restrictions on spending, or at least in the recent past. I shouldn't say always. But certainly before this election, in June of this year, there were new rules that expanded what they're referring to as the third-party advertising rules. And what they really identify is where an organization, charity otherwise, spends money on advertising either about a party or in certain circumstances about an issue that is connected to the party, or it could be the politician, they have to register under the Elections Act and account for the spending. And then there are certain maximum limits, which are $500,000 in the election period, and there's also a pre-election period where they were having restriction. So these rules are really about, you heard people talk about PACs in the United States, and about when the finance changed the charity rules, about this was going to open up third-party spending and spending on issues. I think the Elections Canada rules are really designed to try to limit third parties who aren't in the party or the politician themselves from spending. So they're intended to limit or at least identify where parties are spending money. So they are somewhat new restrictions because they apply more specifically now to issues that are also identified with political parties in a way that they weren't as specifically applied before.
So just in a Venn diagram sort of way, there are things that are permitted to charities under the Income Tax Act.
That's correct.
That would be restricted or prohibited under the Canada Elections Act. Is that the...
That would either be restricted or that they have to disclose and account for.
Right.
The prohibition that's in the Canada Elections Act is you can't accept money from a foreign source to do paid advertising in connection with the election. The registration requirement is with respect to spending money on media that would be seen to be supporting a particular candidate, a particular party, or an issue that could be identified with that. So and that's the confusion one, is the issues, because issues can be identified with a party but also with an organization. So for example, environmental organizations. There was a statement made by one of the leaders of a political party about climate change not existing. So all of a sudden everybody was concerned that meant that anything they said about climate change was going to require them to register under the Elections Act. Not that they couldn't say it, but that they would have to register and account for it.
And is the registration, so there's certain thresholds, and I like the Venn diagram image because there are, I think boards and managers need to consider the number of the rubric that they now have. They are considering what's there in the Income Tax Act, and they're now considering, probably to a greater degree, just because of the scrutiny around this, the Elections Canada's purview and regulatory regime. But the threshold there, I mean, you've named the fact you can't take foreign funding to promote a position during the election. There is a threshold in terms of when you must register, though. And is just by, I mean, if you're sending a tweet out or posting on social media about, say, that climate change is real, is that, as soon as you do that, do you trigger the requirement to register? Or is this about, I've seen pieces, this is about the spend you're putting in it. So if you're buying Google ads to do this work. So what are the limitations when you're doing that sort of activity?
There is some gray in the answer to that question, but it is generally paid media. So if you're spending to put an issue out there, to push an issue out there on social media, you might have to count it. But if you just put it on social media like you normally do, the general sense is that would not be something that triggers the registration.
And again, of course, you can promote or oppose a policy. It's the partisanship that will get you offside. Is that correct?
With respect to the election period under the Canada's Election Act, it's actually just if it's an issue that's identified with a party and you pay for media that wants to push your position on that issue, then you would probably have to register, the conservative thing. There's no downside to registering. It just is a requirement that you register. It doesn't mean you can't do it. It just means you should register and be transparent about doing it. So it doesn't make it partisan for CRA purposes to pay for media to push that issue out because it's an issue that's related furthering your charitable purpose, but it may trigger the Elections Canada registration requirement.
Yeah, no.
What should people look at? So where's that test stated and formulated, and how will people know? Is there a form of words or a publication that they should?
There are publications on the Elections Canada website, and there will be links that they can access through the webinar materials that are attached to this webinar. But Elections Canada goes through and identifies that. And there are certain charts that they will put out. But Elections Canada has a third-party advertising page where they've put all their materials out, where you can follow that. There has been a lot of confusion about the latter point. I mean, if you're promoting a political party or a candidate, that's partisan for CRA purposes. As a charity, you're not going to do that. I think for charities, the confusion has been around what can we say about the topics that are near and dear to our heart during the election period and not be required to register. And my only comment on that is, I'm not sure why we think registering is bad. I mean, if you want to say something about an issue and you want to spend more than $500 on it, and you're saying it in a way that isn't partisan, but it may still be an issue that's furthering your purpose, the fact that you have to register means you can do it, as long as you don't spend more than $500,000 on it.
I mean, this is not much different than if you want to drive a car, you're going to have to register, or get a license, perhaps.
Yeah, you get a license.
But
so
you need
there's
to
an
be
element. Yeah, there's an element
about
of that.
what your intent is.
And the confusion is that I think that sometimes we think registering means it's partisan, and that's where the language is confusing, because the Elections Act use of that term is different than the Income Tax Act use of the term.
So sorry, I was going to just take it up to a level, because I just realized that under the broader rubric, the Income Tax Act or regulations by CRA, the issue of removing advocacy restrictions isn't a carte blanche to do whatever you want either. There are still restrictions there. For instance, it has to be attached to charitable purpose, or there are ideas around what's direct partisan and versus indirect partisan activity, and restrictions on those. I don't know if you could speak to those, because those also could get you offside whether you're in an election or not.
Right. So, but as I said at the beginning, I think the rules governing advocacy activities now are pretty broad and general, and not that easy to run afoul of. The conditions are simply that what you're doing is connected to your purpose, and that your purpose is charitable. So if you're registered, and you've been registered recently with robust charitable purposes, or you've been audited recently and CRA endorses has been an issue out of your purposes, obviously you should look at the purposes and reconfirm. But if they're charitable, then anything that advances those purposes is permissible, provided it's not partisan. And I would think, though, that there would be a question that if you're going to register under the Elections Canada Act, because you're worried about attracting that regime. So Susan just suggested that, well, maybe not. what's so bad about registering? So go ahead and register. I would think that depending on what's going on in your board and your charity, you're starting to migrate towards a partisan position. And you'd want to be careful about attracting a CRA negative view of what you're doing. So the point I'm making is, does the fact of registration, is that somehow a semi-admission of culpability?
And I think that CRA has tried to clarify that that's not intended to be. I hear what David's saying, and I think where the Elections Canada Act change this year makes that a more difficult issue, because I think historically that might have been the case, but is that now that the Elections Canada Act wants organizations to register if their issue is identified with the issue that's in a political party's campaign. And it doesn't say that it's the charity picks up the political party's issue. It's the political party may have picked up the charity's issue. So there's no identification with a particular party in the advertising, but you're talking about immigration or you're talking about child welfare, and it happens to be in a campaign that they're going to do some kind of support or the child tax credit, and it's very similar to what the charity may have said. From an Elections Canada viewpoint, their position is they'd like to see you register if you want to talk about that, but I don't think there's anything partisan in particular.
So this is a bit different, because I think one of the analogies would be if you are politically active and for instance, you're on the Hill in Ottawa, you're going to end up having to register as a lobbyist. This is not all that different than having to register with Elections Canada if you're going to take positions. The trick is that in the case of Elections Canada, you have to understand if you're speaking to an issue that's becoming a campaign issue. Is that sort of and that's not as clear a test by any means.
It's not clear, and I think that's where the confusion has come from. Because in the pre-election period, they talk about the issue of advertising as partisan advertising, but in the election period, or the phrase, sorry, I shouldn't have said it that way. The advertising they regulate is partisan advertising before the election. Once you're in the election period, they want to try to also get you to register if you're doing issue advertising. So it's sort of a narrower, it doesn't matter whether you're being partisan or not, they want you to do. And it's actually, you asked David about the indirect partisan, it's actually sort of a little bit, it's if you support a particular issue and a party identifies with it, where is
so
the line? And I understand what you're saying.
I'm having trouble seeing, because I think what's going to happen in your minutes is, if we don't have any specific example in mind, but what the CRA auditor will look at is all the background information that's available about the decision-making process that went into making that decision to register and participate in some way on an issue. What do the rest of your records look like in your minutes? So if you look at the CRA guidance, they say we'll look at your minutes and we'll see why. So the background conversation might be, we should get out in front of this issue, because if we don't, such and such is not going to get elected. So let's get out in front. Well, watch out for Elections Canada. We have to be careful. So maybe we should register and watch out for CRA, so this won't be partisan. So our message will be registered and it won't be partisan, but the background conversation is entirely partisan or somewhat partisan, and there's a record of it.
I think that CRA has come out and said that that's not where they're going to go with indirect, but it's not an area. I mean, we're taking two statutes with two different purposes and two different regulatory regimes, and we're trying to match them together. So there's definitely caution. It's definitely an area where you should be careful. But I think for organizations to tell them not to talk during the election campaign about their mission and their advocacy is difficult. And I think there's lots of scope for them to talk if they want, and they may not be spending anything on it. And if they're not spending anything on it, then they don't necessarily have to register. But if they wanted to spend something, they could register.
Well, it sounds, David, like one of the solutions is just to take poor minutes and not have enough details.
Well, there's that
but I am worried that there is this new provision of indirect partisan activity, but also that right there, any conversation that might have happened around a boardroom table with some intent to understand that as an organization, our best outcome would be that X party gets elected versus Y party. As soon as that conversation is recorded or happens in a formal meeting, triggers the possibility of review that this is a partisan outcome, even though all the public-facing activity is not, or doesn't appear to be anyway.
Right. Just to pick up with that example a bit more, supposing the public-facing activity is an increase by maybe twice or 3 times as much. So your charity has been interested in this issue and has been carrying on permissible political activities under the Income Tax Act for the last 5 years. But then the election comes along and you triple the spending or triple the devotion to that issue. And again, supposing you're okay under the Elections Canada Act in theory, you've registered and you're okay on that front. Have you increased your audit profile for CRA?
The question of whether you've increased an audit profile for CRA comes back to, in my mind, more to the chill. Is CRA going to, I'm not, in the sense that, are they going to look at that and say, oh, that means this must be partisan? And I don't get the sense that that's going to be the case on all issues. On some issues that may happen because they're more sensitive and higher profile issues. So I think David's points about how do you make the determination between the two and registering and what you say internally and what you say externally are all valid. The indirect partisan for purposes of the Income Tax Act has always been a problematic phrase, because what exactly, what does that mean? And there's been a lot of discussion about that, and there was a lot of advocacy around removing the indirect when the Income Tax Act was changed, because it's really hard to know, is it intentional indirect? Like, is it, we're saying it in, at the board meeting we say, well, we really want to do this because we want to be partisan, but we can't, so we're going to do it this way. Or is it just simply that the organization believes a certain thing that is more in line with one party than the other? Right. And I think what would generally be hoped is that it's not that our position happens to be more in line with one party than the other that is indirect and we support it. It's the behind the closed door saying, well, we're going to do X to be partisan, but we're not telling it that way. And CRA has sort of indicated that that would be where they would go, but there's no guarantee. David's completely right. And so you have to be.
So add another fact. So we tripled our spending during the election period on this issue. And we actually, in our position, we have a specific policy proposal, a solution to a problem, and it happens to line up with what the policy option supported by one political party. That additional fact, are we indirect political?
Is it a new solution? Or
supposing we've always supported.
If we've always had this solution, and the fact that the party has saying that that's what they're going to advocate for, I don't think that becomes indirect partisan.
So let's take this up a level.
But this is obviously at a,
sure.
It's getting to a point where we're dancing. We're not. It's important.
Well, and I think that's one of the questions I want to get to. But I'm going to say that for a couple of minutes because I want to think about what is this going to mean in terms of future tests of these regulations or laws. But in the meantime, before we get to that, I just want to understand. Let's wake up on October 22nd and say, okay, we've survived the election period, and we don't think we've either registered or not, or we've as a charity we've kept our nose clean. There's still the capacity, and what I hear frequently is that charities, now that there's this greater freedom, are not necessarily taking advantage of the greater political freedom that they have to advocate. What is the advice, I guess, on the positive side? That is, look, this is what you can start thinking about doing, and of course, on the contrary, what do you need to be cautious of at the board table about this is not carte blanche to do just anything you want in the political space, but it is a much, much greener pasture for folks. Do you have a framework, or what would be the advice that you're, a chair of a board saying, we want to really push on some issues. What can we now do, and how far can we go before we're going to be found not in compliance? And what happens? Do we get a notice from CRA? Do we get revoked? What does the new regime allow for or penalize?
It basically would permit you to do advocacy, the organization to do advocacy that is, it could tie to its charitable purpose as being furthering a charitable purpose, and that could include calls to action. Right. It can include petitions. It can include research and then publicizing about it. It can include calling on, sharing that with members of all political parties. It can include calling on government not just a particular individual, to make change, and promoting that to the constituency and in the public domain, being interviewed about it. It is really about advocating for the purpose for the charity, or about an issue that's furthering the charitable purpose. And they're really, provided you're not saying to in the public space, or you're not in any way suggesting that one party or one particular candidate or something supports it versus another, or dividing. You basically have, as David I think said earlier, a bit of a carte blanche to advocate now.
And what do you think is going to happen to test these limits? I mean, someone's going to come around as a charity somewhere and say, look, all of these political activities somehow, stretching the argument fairly thin, are attached to my charitable purpose. I can do all sorts of things. We know someone somewhere will test these. What do you think will be the biggest legal questions of understanding these new regulations? Like where and what, to some degree, should be the things we should be testing going forward? To say, what does it mean by, for instance, indirect partisan activity? Because if to some degree, I think people are going to want to have some certainty around these guidelines. Yeah. And can we actually devote 100%? It says we can devote 100%, but are we going to be caught up in audits ad nauseum because of this? Do you have a sense of what that future might look like, or what do you think will be the first tests, or should be the first tests of these regimes?
Well, so a couple of questions there. So one sort of audit approach would be these activities. The auditor says these activities don't line up with your purposes.
Right.
So I haven't seen that on an audit yet. And I'm just thinking through, just based on general experience with audits, that sort of thing. I think it's extremely difficult for the auditor to make that argument stick. It's very easy to defend against it, I think. You have to pay attention to your object. So the charity needs to do its homework. It needs, if it's undertaking an activity, it should check that activity against its objects. Okay. But that should be fairly easy to do. And generally speaking, your object should clearly state your purposes. So you really shouldn't get into trouble with activities that pursue those purposes. You would have to have a collateral purpose if your activities sort of missed the mark. There would have to be something else you're doing, or you think you're doing, in an activity that doesn't line up with your purposes. But why would that be? Like, why would a charity do that?
I had one scenario where it was an environmental charity, but they were involved in distribution of pharmaceuticals in developing countries. And that question was raised, well, this isn't related to your purposes. And the argument, the response was, well, but it is, because if people aren't well, we can't save the environment. We need to get people. So there are scenarios where you could see that it may not be, and I'm not suggesting that was ever accepted. But it's a scenario where I've seen the question of is the activity or what you're doing related as closely enough to your purpose.
Now that you mentioned that, I've seen that too. But normally, when you're dealing with a difficult audit, that sort of approach is one of 8 points they make.
Yeah,
and usually our answer is, okay, good point. But what they were doing was charitable, so fine, we'll amend our objects and we'll make sure that our activities are in line with our objects, unless there's something untoward happening. That would be the approach historically. But now you wouldn't have that out. So it's a good point. You wouldn't, because what you're doing is political, the activity, not charitable. So you wouldn't be able to say, fine, we'll amend our objects because what you're doing is not charitable.
Yeah.
So then the other question of what is allowed in terms of, or not allowed in terms of indirect partisan activity. I mean, that term sounds like it's ripe for some questions and potentially even a court case. I wonder. Is that where you think that may end up, or is that one that will stay to the side?
It's not really defined. I mean, it's direct or indirect support of a party or candidate, and sort of what does that mean? That's the area where there may very well be, if there's something that CRA decides to challenge, it may be in that language, and it may come out that that's where they want to see some tests around it, because otherwise the new rules in the Income Tax Act are quite broad, and it would be very hard to see what else they're going to litigate or to audit on, except for the point of, is it related to your purpose?
And to make an indirect partisan activity arguments stick, what would they want as evidence? What would they want to prove? Where the assumption is that they've issued a negative audit letter, they've raised that as the issue. They would point to the evidence. What evidence would they point to? What evidence would they like to point to? If they wanted to take it all the way to court, what records would they be looking at? So is there anything in the written record that indicates an affiliation with a political party? But if there's not, what evidence do they have that it's indirectly partisan?
I don't think they do. Mm-hmm. Personally, I think it's indirect partisanship is a very difficult level to meet unless there's something very clear in board minutes or something that the reason I'm doing this is to be partisan, but I'm trying to do it in a way that's not, and otherwise. And sometimes we see that those things are in board minutes, but we hope that they aren't.
Okay. So it's more about intent than evident
exactly.
outcomes. Okay. Sorry, yes.
I was going to say, what the one thing we always do as lawyers is we ask what's the downside consequence of being offside these rules. So under the Elections Canada Act, if you're in breach of those rules, what happens?
I think if you don't register, or if you do something like obtain foreign funding for purposes of this, the maximum penalty is something like $100,000, and there are potential for criminal sanctions. I think you would have to be quite egregious to go there. I don't believe that someone that's spending $1,000 on not register and doesn't register will somehow find themselves with that kind of a consequence, but there may be a letter and there may be a notification.
Now that's different than understanding your rules under the Income Tax Act. I mean, previously it was revocation. I mean, this is you will lose your charitable status. You can still operate as a nonprofit, but not as a charity. Now you're talking about under the Elections Canada Act, this could be fines and criminal prosecution. This is quite a different level of penalty than what many would have considered at a board table.
Yeah, I mean, loss of your charitable status is probably worse if you think about it. But for the purposes of the organization, having a fine, none of it would be positive. And,
no, of course
certainly, to come back to where David was speaking before, just having a fine under a certain statute where you're offside the act. I mean, who knows what CRA would think of that and where they would take that, but it would be, they might look at it, but at least you're not losing your whole charitable status. But I'm not an complete Elections Canada specialist. I'm a charities lawyer, but I don't imagine that for purposes of, your general, we haven't quite met the threshold. On the getting funding from foreign sources, because that's a prohibition not only for charities. Like, understand the Elections Act rules apply to all of us. They don't just apply to charities, but there is a strict prohibition about foreign money coming into the country and being used by third parties to support any of the candidates or political parties, or doing any kind of third-party advertising.
But Russia can still buy Facebook ads. Is that
apparently that maybe. I don't know. I don't know where they're buying them, but they can't buy them and bring them into Canada.
If I understand some of the other changes in the broader regulation, the advocacy rules, and maybe I'm reading this wrong, but I understand there's a change in terms of charities' capacity to advocate for changes in laws versus upholding laws, or something along those lines. Am I reading that correctly? Is there a change in terms of how much you can advocate in terms of what changes are allowed?
Yes. It used to be that under the limited rules that David talked about, that it was accepted as charitable to be upholding the law. So if there was a law that said you can't dump your garbage into the Lake Ontario, and that was what the law said, and an environmental charity wanted to say to the City of Toronto they're doing it in contravention of law, that would have been okay. That wasn't considered political activity, that was upholding the law. But you could not, anything that was considered advocating for changes was considered to be in the limited bucket, the 10% bucket, the 10%. Okay. With the new rules that say you can do up to 100%, advocacy, you can now advocate for changes to the law, whether they be here in Canada or anywhere in the world, and not worry about that being considered to be other than charitable. So that is a change. It has clarified, because what was upholding the law was also subject to some debate.
So David, what other advice would you be giving those sitting around a board table or a CEO of a charity at this point in time to say, okay, this is what you really need to be concerned about? Anything we've missed in terms of things they need to be thinking about given all this change?
Maybe not really, but except for one fact, which is you really don't want to attract the attention of CRA, and you don't want an audit situation.
Right.
So that argues in favor of being careful, prudent, conservative in the decisions you make, especially during an election period, I would say. So depending on the client, that the general advice would be, well, be careful, because you don't want an audit situation. Why? They can go on for a long time. They can be difficult to deal with. I've had situations that have lasted 8 years and 3 years. So it's a long, grinding process. So don't provoke an audit.
Now, these audits, though, if I understand, there won't be political activity audits. There will just be general audits. Is that?
That's right. So do we know how CRA picks its candidates for audits? We speculate what sorts of reasons cause CRA to audit a charity, but and I think we're told it's generally speaking random, but
generally speaking random. Sometimes identified issues.
Yeah.
So they might pick something.
Mm-hmm. Right, but it won't be on the auspices, at least on the front. It won't be because of political activity anymore, at least as the current government has declared.
Based on the current, if they thought something was partisan, it might get raised. But again, I think that the rules that the previous set of audits were related to were the old rules, where you were limited in the amount of resources, and they could be. That was not about advocacy that was partisan. It was about non-partisan advocating in furtherance of your mission, and that's not going to trigger it anymore. And I think I think charities do need to be cautious. I'm also one who believes that charities need to understand the rules. They need to get appropriate input, and I mean, the chill is the chill. If they run away, if there has to be a point in time. There usually is a place where you can get confident about doing some of what you want to do, and you should be able to do that, because otherwise you're shutting charities down. And I think that's something that I'm always nervous about, because I think the advocacy of charities has been very important to where we are today on a number of issues, and I just hate to think that the way we regulate today is creating a scenario where those benefits to our communities are stopped because people are afraid of them.
Well, that might be a good spot to sort of think about as we wrap this up. About this is a big positive step. This is about opening up capacity to advocate, opening up the voice of charities. But I think the conversation today, as much as we've cautioned organizations on what they cannot do and what they need to be thoughtful about. This is new territory, and this is bold new territory for a lot of organizations in terms of what they should be doing, and hopefully to undo the advocacy chill that we've seen over the last few years. What will that mean? And this is sort of more broadly speaking, maybe not on legal terms, but I imagine this is going to create something very interesting of charities waking up to what they can do as long as they're cognizant to these rules. One, it may mean more people on your doorsteps asking key questions.
Perhaps. I would suggest to you, Owen, that the reason that we don't smoke today has a lot to do with the advocacy that charities have been doing for years and years, and the reason we're healthier today. There's certain types of advocacy that charities have done probably without really being concerned about limits, because we all thought it was good and we didn't really worry about it. The areas where you see people get concerned with advocacy is where you're in an area where you're dealing with an issue that also has controversy attached to it, that has debate attached to it, and that's where you see the application of these rules. I agree with you that we don't want the chill, and we want people to be able to advocate with abandon. I'm not sure in all areas it's going to make a lot of difference, because I think they were doing it. In the areas where it may be harder to push community in a direction they want to. I don't want to use forward or backwards. This gives them more flexibility to be talking about the issues than they used to have, I think.
And David, for you, I mean, any last words in thinking about, similarly, does this open up new territory, or is this, charities have always been able to do a lot, now they just have a little more elbow room perhaps to make that work happen?
So I'm wondering whether there will be many charities that raise their level of spending on advocacy to 40% or 60% or 100%. It'll be interesting to watch to see how that plays out. And then I think maybe the pressure point back would be whether your donors are happy with your activity. So that'll be the constraint. But it'll be interesting to see whether that sort of charitable approach develops.
And any last words you'd want to extend to charities who are considering this or thinking about their activity, either in the election or post October 22nd?
For me, it's watch webinars, learn as much as you can about these issues, and consider it carefully within your organization, but don't run and hide.
For you, anything, Dave?
Well, being a lawyer, I would say...
I'm a lawyer too.
Yeah.
Just have a different perspective. No, I'm just kidding.
I would say look at the texts, look at the subheadal text. So for the CRA rules, look at the CRA guidance. It's on the conservative side, but it's generally it's very well structured and very well stated and reasonably clear. So you use that as a guide, and the same thing with Elections Canada. Yeah. Go to the horse's mouth and think about the rules that they're stating.
Well, and I liked the fact, Susan, you mentioned earlier, there are resources on the Elections Canada site. Mm-hmm. They've gotten better, I think, both CRA and Elections Canada, at describing and providing resources that are a little clearer, a little easier to understand. And those resources, I think everyone should avail themselves of those, as well as the slides that will accompany this webcast. So find the resources. We've also seen lots of organizations that have helped to interpret some of this, local nonprofit agencies, et cetera, that advocate on behalf of the group, often talk about election issues and how do you behave appropriately during this period. So I'd encourage people to go and find those. In wrapping up, though, I want to thank you both. I want to thank the Pemsl Foundation for putting this together. Thank you both for your time and sharing your knowledge and expertise. It's been great chatting about this very timely and topical issue. And I hope it's useful for you as you consider what actions your charities take in advocating for your positions and policy positions and changing laws, upholding laws, whatever that might be, in nonpartisan ways. So thank you very much. Thank you both, Susan and David.
Thanks very much, Owen. Thanks, David.
Thank you.